My name is William Reid. I'm an attorney at Community Legal Services. We provide representation in civil matters to low income, if you meet certain income qualifications, and we mostly represent tenants, by the way. However, this presentation is kind of geared toward landlords, although there's plenty of information regarding tenants as well. Arizona Residential Landlord Tenant Act is the body of law that governs the relationship between landlords and tenants. As you see here, it's available at the Arizona Department of Housing website. There's certain exclusions from the act to which it doesn't apply. The main one, I think, in Yuma is the mobile homes and recreational vehicles, and that is subject to the Arizona Mobile Home Parks Residential Landlord Tenant Act. It does not apply if the trailer and the space are owned by the same person. So where you have separate ownership, that's when that act applies. It does not apply to institutions providing medical, educational, religious services. It does not apply to public housing when the public housing entity owns the structure. It does apply in the Section 8 voucher program, however, because that's private landlords for the most part, if not entirely, actually. It does not apply to an employee of the landlord. A lot of times you'll see the landlord in a multi-unit, and a multi-unit building will allow and have an employee, a maintenance guy or whatever, give him a unit as part of his employment. Situation is not required to go through all the eviction procedures, et cetera, that are required under the act. The governing document is usually a written lease or rental agreement. That controls pretty much the entire relationship. It kind of lists the things that should be included, which is when it starts, how long it is, whether it's usually they're annual or 6 months, the amount of rent and how and when it's paid, the amount of the deposit, and we'll get more to that in a later slide. Fees, concessions is when they'll give the tenant a 1 month free rent, for example, when they're moving in to get them to move in. A lot of times where the tenant breaches the lease, the landlord will put a provision in the rental contract saying they're able to recover the concession, and that is permissible. Crime-free addendum. I actually brought a handout of the crime-free addendum as well as a notification regarding medical marijuana law. It basically specifies the circumstances when the tenant is engaging in criminal activity where the landlord can terminate the lease. The other one regards medical marijuana, and although medical marijuana is legal under state law, it's illegal under federal law, and a landlord is not required to allow medical marijuana on the premises. I'm going to talk about disclosures. There's a number of disclosures a landlord is required to make at the beginning of the lease when he enters into the lease agreement. He has to provide the name and address of the person, of the manager of the property, the name and address of the owner, if that's different. It's required to provide that the Landlord Tenant Act is available at the ADOH website, as we just went over. The landlord is required to provide a move-in inspection form and notice that the tenant can be present at the move-out inspection. And he's also required to provide bed bug information, which is addressed a little bit later on in the bed bug statute. Notice. Generally, the time for notice, there's a lot of notice provisions in the Landlord Tenant Act. It usually refers to business days unless it specifies in the statute that it's calendar days. And there are several instances where it does specify calendar days. Generally, the tenant is required to give notice either by handing it to the landlord or by certified mail. Security deposits, the max is 1.5 times the monthly rent, although you can include reasonable fees in addition to that amount. The landlord can. Pet fees, for example, or a non-refundable cleaning fee. The presumption is that the security deposit is returnable to the tenant, minus damages or unpaid rent, etc., unless it's designated as non-refundable. So you can make $200 or $300 non-refundable for cleaning charges, as that portion of the security deposit is not going to be returned, for example. On move-out, if the tenant demands in writing, the landlord must provide an itemized list of deductions with the amount due and payable, and he has to deliver that within 14 days. If he does not do so, the tenant can bring an action against the landlord, not only for the amount that the tenant contends is due that's left on the security deposit, but also for 2 times the improperly withheld. So if you've got a $1,000 security deposit and landlord doesn't return any, it turns out that 500 is returnable, the tenant would get the 500 back plus $1,000, 2 times $500 if the landlord does not comply within 14 days of written notice. We have a bed bug statute in Arizona. It provides that the landlord shall not knowingly rent a unit that he knows to be infested with bed bugs. Likewise, the tenant shall not knowingly move bed bug infested personal property into the rental unit. The tenant is required to provide written or electronic notice if it discovers bed bugs. And generally, there's not a separate cause of action for bed bugs, although the tenant can proceed under its usual remedies where the landlord fails to make repairs, etc. And we'll get into those a little bit later. The bed bug statute does not apply to single-family residences. It applies to multi-unit facilities. And I guess the reasoning is bed bugs tend to migrate through walls. We're going to talk about the landlord's duties. The main duty of the landlord is to place and keep the premises in a fit, inhabitable condition. The landlord's also required to comply with building codes that affect health and safety. The landlord's required to keep in good and safe working order the electrical, the plumbing, the sanitation, heating, ventilation, air conditioning, and other facilities and appliances. The landlord is required to provide garbage receptacles for the tenant and reasonable amounts of hot water, heat, and air conditioning. A landlord and tenant can opt out of this and put the requirement on the tenant to make the repairs or alterations, remodeling, etc., if it's done so in a separate written agreement. And for a single family house, for a house basically, there's really no limit to the amount of repairs that can be done, that can be agreed to separately. With an apartment, it has to keep the premises in a fit and habitable condition. It applies more to specific repairs and minor repairs in that situation for apartments. Access to the unit, we actually see a lot of tenants come in with this issue. It usually happens when the tenant's moving out and the landlord wants to show the premises to a potential new renter. The tenant cannot unreasonably withhold access, and that's access to inspect, make repairs, and things like that, or to show the apartment. The request for repairs, once the tenant requests repairs, that's deemed a permission for the landlord to enter. In other words, the landlord does not have to get a separate permission to enter if the tenant asks to come in and make repairs. Otherwise, the landlord needs to provide 2 days notice of his intention to enter. And that's, of course, if the tenant doesn't consent. What usually happens is the landlord to come and knock on the door. Hey, do you mind? I need to check to see if the unit needs painting, etc. If the tenant says fine, no problem. If the tenant says, well, actually, no, I need some notice here, then 48 hours notice is required. Although the landlord can enter in the case of an emergency, the landlord can also enter if the premises are abandoned. That's a separate statute that we're going to talk about later. And as well, if there is a condition that affects health and safety, the landlord can enter immediately or with 14 days notice if it's not an emergency. The landlord cannot abuse the right to access. The landlord should provide notice if the tenant requests. It should enter at reasonable times during business hours generally. And I've actually seen a couple of situations. It's not that common, but where the landlord wants the tenant out and starts demanding access all the time to do this or that. And that's prohibited. If the landlord does do those kinds of things, the tenant has the right to get an injunction to stop the landlord from doing it. He can terminate the lease, and then he can sue for actual damages, not less than 1 month's rent. If the landlord fails to maintain the premises, like we just talked about, the landlord's duties, then the tenant can give notice, and the tenant's going to give either a 10-day written notice or a 5-day written notice to the landlord, depending on the type of repair that needs to be done. So if it's just general non-compliance by the landlord for general repairs, the 10-day notice, and the 10-day notice would say you have 10 days to fix the problem. If not, I'm going to elect to terminate the lease. That's generally the option that the tenant has, although there's some other options, but that we'll talk about in a second. It's a 5-day notice that goes down to 5 days if the thing that needs to be repaired affects health and safety. In that situation, the tenant is permitted to give a 5-day notice. You have 5 days to come in and fix it. If not, I'm going to terminate the agreement. Now, the tenant also has another option, and this isn't used that much for a couple of reasons that I'll talk about. That's when the tenant gives the notice and he says, instead, I'm going to go hire someone to make the repair myself if you don't do it within the specified time. Or if it's an emergency, you can give shorter notice. As long as the amount of the repair is less than $300 or one half the amount of the rent, the tenant has to hire a licensed contractor. He has to provide the landlord an itemized statement of the work done. The contractor has to waive his right to a lien against the property. If all that happens, the tenant can deduct the actual reasonable cost of the repair from the rent. The problem here is that generally licensed contractors, they want the consent of the owner before they go into the premises. Once it gets to the situation, the landlord a lot of times is not willing to provide consent to a licensed contractor to come in and repair, because maybe they want to do the repairs themselves, but they don't want to do it within the specified time, or the relationship is just broken down. If the landlord fails either deliberately or negligently to provide AC, heat, water, major essential services, basically, then the tenant has a few options. First of all, it's got to give reasonable notice of the problem, obviously, to the landlord. Reasonable depends on what the situation is. 115 outside. That reasonable notice to me is like, get over here right now, please. It shortens depending on the severity of the problem. The tenant, if the landlord fails to do so, can go and procure reasonable substitutes and deduct that from the rent. Now, remember, the tenant's got to give notice that he's going to do these things before doing them. The tenant can also seek damages for the diminution or the reduction in the fair rental value, or the tenant can go and get reasonable substitute housing. If it's a negligent failure of the landlord to remedy the problem, then the tenant doesn't have to pay rent during the time that he's out of the apartment, that he's got the substitute housing. If it's a deliberate failure, then the tenant can not only gets free rent during the period, but can go back and require the landlord to reimburse him for the cost of the substitute housing, not to exceed the regular rent, the prorated amount of rent during that period. Or actually, I should say it's up to 1 month's rent. And then if it's negligence, then the tenant can only recover 25% of the amount that exceeds the prorated rent. Look at the statute if you get in the situation, 33-13-64. Okay, this permits the tenant to terminate the lease early without penalty and get their security deposit back if they're the victim of domestic violence or sexual assault on the premises. The tenant has to do it within 30 days of the incident. He has to give written notice and specify a termination date. And that termination date cannot be more than 30 days in the future. And of course, the tenant is liable for rent. If the landlord requests, the tenant has to provide, a copy of a protective order or investigation report from the police. Actually, if the tenant is convicted of giving false information to the police in this situation or getting false testimony to get an order of protection, then the landlord can come back against the tenant and sue her for all his damages arising from the early termination of the lease. Tenant can also request the landlord to install a new lock, and that can either be as an alternative to moving out or, during the time that she's still at the premises until she moves out. And the abuser is only permitted to return to reclaim personal property if escorted by a police officer. The tenant has duties as well. The tenant needs to keep the premises clean and safe, dispose of garbage, keep the plumbing fixtures clean, use reasonably the electricity, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities. The tenant has a duty not to deliberately or negligently damage the premises. He also has a duty to respect neighbors' peaceful enjoyment in multi-unit facilities, and a duty to notify the landlord in writing in the event that there are repair issues. The basic principle is the tenant is responsible for damage beyond normal wear and tear. If it's negligent or deliberate, then the tenant can't recover. You'll see later that the tenant has a right to maintain a counterclaim in an eviction action for damages to the apartment. If it's the tenant's fault, entitled to claim those back against the landlord as a reduction on rent. All right, if the tenant fails to comply with the rental agreement, and that means other than non-payment of rent, then the landlord can provide the tenant with a 10-day notice to remedy the situation that's causing the breach of the lease or to get out. and would commence an eviction action if the tenant doesn't remedy the situation or move out within the 10 days. If it's a situation that the tenant has caused that affects health and safety, the landlord can do the same thing, but with 5 days notice. In the situation with health and safety where the tenant, again, this has another problem, has caused another problem affecting health and safety, the landlord does not have to give the tenant an opportunity to remedy the problem. He can simply say, you got 10 days to get out, and if the tenant doesn't do so, then he can commence an eviction action. The breach by the tenant is irreparable, and that generally means the statute specifies a number of things, including drugs, assault, prostitution, and those are probably the main ones. The landlord can give immediate notice to terminate the lease, and if the tenant doesn't get out, can commence an eviction action. And this is 99% of the cases that everyone sees where the tenant has failed to pay rent. In that situation, the landlord gives a written 5-day notice. That 5-day notice says you have 5 days to either pay me the amount due plus late fees or get out. The tenant generally does not get out within the 5 days if they fail to pay. And they generally, at least the ones I see, obviously, they do not pay in the 5 days. Usually the tenant is going through problems. You know, someone died and they had to pay for the funeral. There was medical costs. There's a lot of very compelling stories. Unfortunately for tenants, that is not a defense, the non-payment of rent. If the landlord wants to wait for the rent, of course, she's entitled to do so, but he doesn't have to. And a lot of people do come in thinking, well, yeah, I'm $1,000 behind, but it's not a defense. It's unfortunate, but it's not. If they don't pay within the 5 days, then the landlord can, it says special detainer action, which is basically what we know as an eviction action. The tenant can pay after the 5 days expires up until the time the landlord gets a judgment. The tenant can still pay the landlord the rent, the late charges, the attorney's fees, if any, and the costs, and make the eviction go away all the way up to the point of judgment. Past the end of the trial, completely within the landlord's discretion. If the landlord wants to let tenant reinstate under whatever terms she likes, then of course she's entitled to do so. The landlord in the eviction action can also recover not only the unpaid rent, attorney's fees, charges, it can also recover damages for any injury tenant caused to the premises. And there's a couple things that the landlord cannot do. In the event of an eviction action, the landlord cannot cut off the utilities until the day after a writ of restitution is executed. So we'll get more into a writ of restitution. But basically the way an eviction action goes is that if there's a contested action, it goes to trial. Let's say the judgment is for the landlord. Tenant is required to get out and pay the landlord a certain amount of damages. After 5 days, if the tenant is not out, then the landlord can go get what is called a writ of restitution. And after he gets the writ of restitution, I believe it's another 5-day wait. If the tenant is not out in 5 days thereafter, then they can get the constable to go and actually, forcibly remove the tenant from the premises, remove their property. I don't know if you've ever seen that, but it's someone with all their property out on the sidewalk. It's rough. I don't advise it. But the landlord still does have to provide utilities all the way through that process. Can't cut off the utilities until the day after the tenant is out. Now, the landlord has to go through this process to evict the tenant. Before filing, you have to give the tenant the notice and then commence an eviction proceeding. A lot of landlords don't know the law and are impatient and will do things like, I've never seen a landlord actually unlawfully remove or lock a tenant out. I have seen a few times a willful diminution in services. In other words, the landlord will cut off the power while the tenant is still there to get them out. If that happens, the tenant not only can recover possession if removed, but they can terminate the lease. They can get an injunction requiring the landlord to turn the power back on, and the court will order the landlord to do so immediately, no matter what. Even if there's non-payment, that the tenant was supposed to reimburse the landlord for the charges and the tenant hasn't done so, the court will still require the landlord to turn the power back on, pay the damages, and you can try to recover them later. But get the power back on, and then they're subject to a penalty, generally 2 months rent, in addition to any other damages that the tenant might pay. Damages not more than 2 months rent or twice the actual damages, whichever is greater. So the landlord can suffer a lot of damages in that instance. Generally, this regards guests at the premises. The tenant not only can be held responsible for the actions of the tenant's guests that violate the lease agreement if the tenant was aware that it might occur and didn't attempt to stop it. But also 33-1378 provides that guests that remain without permission, trying to imagine that situation, but they can be removed by the police. You do not have to, landlords do not have to evict a guest that refuses to leave. You simply call the police. And that's generally a no-no. Usually the police are very hesitant to do this type of thing, and as a general rule, err on the side of requiring an eviction proceeding, especially if there's some indication that the person has a right to be there. These are the landlord's remedies event that the tenant abandons the premises. And so the rule is an abandonment is either the tenant is absent for 7 days without notice to the landlord that he's going to be absent, and the rent is at least 10 days past due, and there's property in the apartment. So if there's property in the apartment, the tenant has to be gone for 7 days, and the rent has to be at least 10 days past due. If the apartment is empty but locked, then in that instance, the landlord only has to wait 5 days of absence, and then the rent only has to be 5 days past due. And then in either of those situations, it's abandoned. The landlord first has to give notice by certified mail to the last known address and post a notice on the door regarding abandonment. And then if there's property left after the landlord re-enters, within the 5 or 7 days, as the case may be, the landlord has a number of options and responsibilities regarding the property. If it's junk, they can basically throw it away. They can donate it to charity. They can sell it as well. In any event, they want to keep an itemization of everything that's in there for the tenant's review. If it's valuable, relatively valuable stuff, the landlord has to store it and can charge them for the storage fees and give notice to the tenant that he's storing it. And if the tenant comes and wants to pick up the property, all the tenant has to pay are the storage fees to get the property back. The tenant is not required to pay the back due rent in that situation. That would essentially be something called distraint of rent, which is where the landlord holds the tenant's property as collateral for payment of rent. So pay me the rent or you don't get your property back. And that is not allowed. We talked a little bit about the eviction process. This just kind of goes through the steps. The first thing is the notice, whether it's the 5-day notice or the 10-day notice to pay or quit that the landlord has to give. The summons says there's an initial appearance on so-and-so and date. It has to be at least 5 days after service of the summons. And the tenant, you have to appear, this time and place at this court. The complaint, generally, the landlord's going to want to state the reason for the eviction. You always want to attach the 5-day notice to the complaint. You want to say, how much rent is due, how you calculated that amount, how much late charges are due, that you're seeking attorney's fees and costs, etc. The next step, after you pay the filing fee for the summons and the complaint, and they issue the summons, I should say, then landlord has to serve the summons and the complaint on the tenant. And generally the way that's done is through, as you would serve a regular complaint under the Arizona Rules of Civil Procedure, which is have a certified process server delivered to the tenant's residence and either hand it to somebody, or in some instances, I believe they can leave it at the premises. There's also a post and mail procedure. Basically, it says the landlord can go and post the complaint and summons on the door and then send it by certified mail to the tenant. The problem with that is that it slows it down because it extends it by 5 days under certified mail, because it's presumed that the tenant doesn't receive it until 5 days after you send it by certified mail. So it slows down the process, and that's probably the main reason that it's not used. The initial hearing, the initial return, as it states here, under Rule 11, Rules for Eviction Actions, is the tenant does not have to file an answer for the initial appearance. The tenant's going to state at that time whether he or she has a defense or believes she has a defense to the eviction. If that is the case, then if possible, the judge is directed to have the trial at that time. What usually happens is that the judge says, are you available on this date, 4 or 5 days down the line, and we'll come back and we'll have a trial at that point. And if that happens, in the meantime, the tenant has to file an answer setting forth the defenses and the counterclaims, if any. The tenant is permitted to counterclaim. And most of the counterclaims would be where the tenant hasn't paid rent, but at the same time, the landlord has not made repairs despite notice. And the tenant would be able to argue in that situation that the tenant was damaged by the landlord's failure to make the repairs. And so the rental value, if the rent was $1,000, the tenant could say, the place is only worth $500 because the landlord never made these repairs, and perhaps either get a reduction or a set off against the amount of rent due. It has to be pretty extreme, though, and it has to be well documented, and the tenant has to have given written notice. A lot of times, tenants will come in and they have refused to pay rent because the landlord has refused to make repairs or has failed to make repairs. That is not permissible. The tenant always has to pay the rent. Not permitted to withhold the rent in order to force the landlord to make repairs, and the landlord can proceed with an eviction action, even if he hasn't made the repairs. But again, the amount that he's able to recover may be less than he normally would, less than the amount of rent due under the lease. Rule 11 are trials. There actually can request a jury trial. It's an abbreviated trial. You can bring witnesses and exhibits and all that, but obviously it's going to be on a real short time period. There's not time for disclosure as a general rule. If the other party requests it, I want to see your exhibits, I want to know who your witnesses are, I want a copy of the lease or whatever it is, then the other party should try to provide it to them before the trial. But there's usually not a lot of time for that, and you usually end up handing the exhibits to the other party when you go to court. Judgments, that's specified in Rule 13A, and that states the determinations that the judge has to make before he enters judgment. The main one is that the tenant was given proper notice and that the tenant was properly served with the complaint. 13B states the form of judgment, and that includes a stipulated judgment. It dictates the contents of the form of judgment. And 13C regards the writ of restitution, which is what you get after a judgment. And it basically says that you can't get it sooner than 5 days. So after the landlord gets judgment, the tenant basically has 5 days to get out. Then the landlord goes and gets a writ of restitution. All right, 1381. A landlord may not retaliate by increasing rent, decreasing services, or by bringing or threatening to bring an eviction action after the tenant does any of the following within the preceding 6 months, it turns out. The tenant has complained to a governmental agency or building or housing code of a building or housing code violation materially affecting health and safety. The tenant has complained to the landlord of a violation under 33-13-24, which is basically has complained to the landlord about the condition of the premises and needed repairs. Or the tenant has become a member of a tenants union, or has complained to a government agency regarding Wage Price Stabilization Act. In those situations, if the tenant has made those complaints within the preceding 6 months, the landlord cannot do any of these things unless, of course, the tenant has failed to pay rent or has damaged the premises. In those situations, even though there has been a complaint by the tenant within the preceding 6 months, the landlord is not prohibited. It's not going to be deemed retaliatory conduct if you have either of those situations. Partial payment, generally landlords should not accept partial payments. That would be my advice. If they do so, let's say the rent is $1,000. The tenant says, I can give you $500 on the first of the month, and I'm not going to be able to give you the other $500 for a couple weeks. In that situation, if the landlord wants to take the $500, there has to be a written agreement between him and the tenant saying, this is a partial payment. It does not waive the right to recover the rest of the rent. The rest of the rent, the other $500, is due, on the 15th of the month. And if he doesn't do that, then that partial payment can be deemed to be a settlement, basically, where the landlord's deemed to have accepted a lesser amount for the total rent. And that can be brutal. You see it a lot. And then after a 5-day notice, the same applies. The landlord just should not accept partial payments after a 5-day notice issues for non-payment of rent. And again, if they do so, you got to have the agreement. And it's a little cumbersome, but I don't think it has to be a real complicated agreement. You probably jot it out on a piece of paper. but it has to say I'm not waiving the rest of the amount and the date that the rest of the amount is due. We've talked about this a little bit. The rules of procedure for eviction actions, those are just the rules that can govern basically the process of a trial. The other party has to make disclosures of the lease, a list of witnesses, exhibits, amount of charges for the preceding 6 months, copies of exhibits. Rule 8 permits the tenant to bring counterclaims. In order for the tenant to bring a counterclaim, it has to arise out of the lease. It can't be on something separate. For example, the landlord was supposed to fix my car and he never did it. You can't counterclaim under those situations in the eviction action. Generally, it would be for damage to the apartment that the landlord didn't fix, and therefore the argument that less rent is due. After the eviction action, tenant has 5 days to appeal, and that's under ARS 12-1179. It's not in the landlord-tenant code, it's in the general statutes. The 5 days is 5 calendar days. It does include weekends and holidays. The tenant can also file a motion to set aside the judgment. 60 days is a reasonable time to file the motion to set aside. But if he files the motion to set aside before the appeal, it doesn't hold up the 5 days for the appeal. Just because you filed a motion to set aside that the judge hasn't ruled on doesn't mean that your time to appeal is extended until the judge rules on the motion to set aside. And generally for an appeal, the appeal does not stay the execution of the judgment. So a lot of times tenant thinks I'm going to appeal and that's going to freeze everything. I'm not going to have to get out of the premises. I don't owe the landlord any money yet. That is not the case. The landlord can go ahead and toss the tenant out under the proper procedures, even though an appeal has been filed, unless the tenant files a motion to stay the execution of the judgment before appealing. Well, the party that's appealing has to post a bond and an amount sufficient to cover the cost of the appeal. Pursuant to 33-1368, it's actually 14 days. The landlord has to hold the personal property of the tenant for 14 days after he evicts the tenant or after the tenant gets out. The tenant has to pay only the cost of removal and storage, does not have to pay back to rent in order to get the property back from the landlord. The tenant is not permitted to access the property to get his personal property until he's paid the landlord for storage and removal costs. He does not have to pay storage and removal costs if he wants to go get clothing, apparatus, books of trade, identification, financial documents, and that would include immigration status, employment status, social security cards are a common one, public assistance, medical care, all that. The landlord cannot hold that property and require for the tenant to retrieve it. 33-1368 also says landlord is bound by the rules that apply in the event of an abandonment of the premises by the tenant where he leaves property behind, and all the rules that apply. If the landlord wants to dispose of property, if it's worthless, can donate the property to charity, sell it, and apply it towards the rent. Landlord's always going to want to itemize the items that were left behind and keep a record, if they sell it, of the sales price for each one. And if there's any excess, which there never is, it goes to the tenant. We'll talk about Arizona's fair housing laws. Generally, it prohibits discrimination in housing on the basis of all these things. And the tenant can get injunctive relief and file a complaint if the landlord discriminates in the housing. A sign that says that the premises are available, and then the landlord says, no, this one isn't available. That's a common one. I mean, never is the landlord going to say, no, I'm not going to rent to you because you're a Christian, for example. Usually there's evidence of it that you have to argue it was actually discrimination. That's about it, really. Does anyone have any questions?